Okay, shall we? We'll continue with question number 8. Which of the following statements is or are correct with reference to a constitutional amendment bill, Article 360? முன்னாடி question பாத்துருமா 7? First statement, wrong. Second statement, an ordinary bill can be detained by the Rajya Sabha for a maximum period of 6 months. Yes, first instance 6 months வரைக்கும் detain பண்ணலாம். ஒருவேளை reconsiderationக்குன்னு திரும்ப வருது அப்படின்னா அது எவ்வளவு நாள் detain பண்ண முடியும்? To a maximum period of 1 month. இது ஜென்ரலா ஒரு பில்லோட டிடென்ஷன் கெப்பாசிட்டி ஆஃப் அப்பர் ஹவுஸ் இஸ் 6 months. ரீகன்சிடரேஷனுக்கு வருதுன்னா திரும்ப ஒரு மந்த் கூட அவங்களால எக்ஸ்டெண்ட் பண்ண முடியும். ஸோ இன் டோட்டல் வித் ஆல் கன்சிடரேஷன் செகண்ட் டைம் ரீகன்சிடர் பண்ணி திரும்ப கொண்டு போனோம்னா பிரசிடென்ட் மஸ்ட் அசென்ட் இல்லையா? அப்போ செகண்ட் டைம்ங்கிறது கம் பேக் வராது. மேக்ஸிமம் எவ்வளோ பண்ண முடியும்? அப்போ 6+1 7 months வரைக்கும் பண்ணலாம். பட் திஸ் ஸ்டேட்மெண்ட் இஸ் ஆல்சோ ட்ரூ. Very first instance, upper house can detain the bill for a maximum period of 6 months. So the option is B, 2 only. Number 8. First statement, wrong. It can be introduced in the parliament only after the prior recommendation of president. No. It can be introduced by a minister as well as a private member of the house. Yes. It is obligatory for the president to give his or her assent to such a bill. Yes. Option 2 and 3. B. Option B, 2 and 3. Question number 9. With reference to the 9th schedule of Constitution of India, consider the following statements. It was added to the Constitution by the first Constitutional Amendment Act 1951. Yes, First Amendment Act. Laws included in it cannot be challenged in a court on the ground of being violative of the Constitution. When it was enacted, it had the immunity. Adukapram by later amendments, it is also subjected to judicial review. So present stand, yes, it cannot, it can be challenged in the ground. Initially, the index pannumodu, it was immune from judicial adjudications, interpretations. So second statement is wrong. Any changes to it require an amendment to the Constitution under Article 368. Yes. 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 Option 1 and 3. Yes. Third statement is true. Answer B, 1 and 3. 10th one. Consider the following statement regarding the power of Parliament to amend. The amending power of Parliament arises only from the part 20 of Constitution of India. Only. No. Amendment Article 368 illama simple amendments எல்லாம் இருக்கு. Change of names இதுக்கெல்லாம் கொண்டு வரும்போது Constitutional Amendment Article 20 part 20ல உள்ள வராது. There are simple majority amendments. So amending power arises only from part 20ங்கிறது statement wrong தான். The doctrine of basic structure is the only limitation on amending power of the parliament. No. Basic structure அப்படிங்கிறது it is the major limitation. Most of the amendments are under the guidelines of your protection of your basic doctrine. அது இல்லாம மைனர் சேஞ்சஸ் ஃபெடரல் ஸ்ட்ரக்சர்ஸ் இந்த மாதிரி சில ஆஸ்பெக்ட்ஸ் எல்லாம் உள்ள கொண்டு வரும்போது அது லார்ஜர் ஆம்பிக்டா எப்படி கொண்டு வந்துருவாங்கன்னா இட் இஸ் அ பார்ட் ஆஃப் பேசிக் டாக்ட்ரைன் கொண்டு வருவாங்க. பட் இட் இஸ் நாட் தி ஒன்லி லிமிடேஷன். இந்த ஜுடிஷியல் ரிக்வயர்மெண்ட்ஸ் ப்ரொசீடிங்ஸ்ல இதுலலாம் கூட அமெண்ட்மெண்ட்ஸ் கொண்டு வரலாம். ஸோ பேசிக் ஸ்ட்ரக்சர் டாக்ட்ரைன் இஸ் தி மேஜர் லிமிடேஷன். இட் இஸ் நாட் தி ஒன்லி லிமிடேஷன். Basic structure define பண்ணாதனால there are so many things which have been under basic structure doctrine or well defined இதெல்லாம் தான் basic structure கொண்டு போக முடியாது இல்லையா? அதனால அது major limitation, not the only. Answer வந்து அப்ப என்னவா இருக்கும்? Neither 1 nor 2. Provided for the constitutional status to cooperative societies. என்னெந்த part? Answer. Part 4A என்னது? It talks about fundamental duties. Part 4A, fundamental duties. So, 1 வராது. Now try to answer. 2 and 3, 3 and 4. இப்பதான் கொஞ்சம் ஆனந்தமா இருக்கு. சரி, ஓகே. Part 9B talks about inducted cooperative societies. Part 9B. Part 9A கிடையாது. ஓகேவா? Part 9A it relates to municipalities. So this 97th Constitutional Amendment Act inducted Part 9B, which talks about cooperative societies. So இதுல Part 3 and Part 4. Option 2 and 3. Option A, 2 and 3. Question number 11. Which of the following features of Constitution are considered to be unitary in nature? Answer. Written Constitution. Federal. Written Constitution is a feature of a federal form of government. Written varadu. Integrated judiciary. Yes. Single citizenship. Yes. Requirement of a special majority for constitutional amendment. No. State has a role in it. அப்புறம் எப்படி அது யூனிட்டரியா மாறும்? Special amendment of constitution requires, if it touches the federal matters, consent of half the state is also required. இல்லையா? அப்போ ஸ்டேட்டோட பார்ட்டிசிபேஷன் வருதும் போதே அந்த யூனிட்டரி பேசிஸ்ங்கிறது dilute ஆயிடும். So this fourth வராது. Bicameralism in the central legislature? No. So option 2 and 3. Option A, 2 and 3. Question number 12. Parliament has exclusive powers to make laws with respect to any of the matters enumerated in the union list. Union listல இருக்கிறதுல எல்லாமே யாருக்கு powers அதிகம்? என்ன மாதிரி power? Exclusive powers. Yes, statement 1 is true. Article 246. The first statement is true. In case of conflict between central and state laws over the subjects in concurrent lists, it is the former that prevails in regular legislative circumstances. Yes. Concurrent list ன்னு சொல்லும்போது ரெண்டு பேருக்குமே powers இருக்கு. அப்படி ஒரு conflict வந்தா யாரோட laws தான் prevail ஆகும்? சென்டரோடது. Article 256. Option B, both 1 and 2. Which central law on the subject matter of the state list will stand in perpetuity unless withdrawn or amended by the appropriate legislature? A law enacted based on the resolution passed by Rajya Sabha. Article 249. Option 1 or other. It is valid for 1 year. It can be renewed. It ceases 6 months after the resolution lapses. So, state legislature withdrawn or amended by the appropriate legislature will stand அப்படினு இருக்காங்க தெரியுமா? Unless state ஒன்னு பண்ணாம அது கண்டினியூ ஆகுமானா ஆகாது. 1 year வரைக்கும் தான் ஆகும். அதுக்கப்புறம் it ceases its operation. So, first one is wrong. Article 249. A law enacted during president's rule. Yes. Yes, it is. Unless adopted by the state legislature, president rule முடியும் போதே முடிஞ்சிரும். அதுக்கப்புறம் அந்த ஸ்டேட் லெஜிஸ்லேச்சர் அதுல அமெண்ட் கொண்டு வந்தா மட்டும்தான் அந்த சப்ஜெக்ட் மேட்டர்ல இருக்கிறது கண்டினியூ ஆகும். So 2 is true. A law enacted during president's rule. Third one, a law enacted during national emergency under Article 352. No, no. So it is valid during emergency and it ceases after 6 months. Fourth one, a law promulgated for the implementation of international agreements and conventions. Yes. So the answer is 1 and 4. Sorry, 2 and 4. C. 2 and 4. Through centrally sponsored schemes. Which of the following provisions enables the center to extend discretionary grants to states through centrally sponsored schemes? 282, Article 282. So that article allows both center and state to make grants for any public purposes. That article acts as a base for the concept of centrally sponsored schemes. So it allows both center and state for granting funds for any public purpose. For any public purpose, அது என்ன ஃப்ரேமா மாறுது? Centrally sponsored schemes ஓட பேஸா மாறுது. Article 282. 15. The governor of a state may, with the consent of the central government, entrust it with any matter which the executive power of state extends. ஸ்டேட்டோட எக்ஸிக்யூட்டிவ் மேட்டர்ல அந்த பவர் ஸ்டேட்டுக்கு யாரு வழிதான் வருது? கவர்னர் தான் with the consent of the central government. That is why he is referred as the agent of central government. So executive power of states. He functions with the aid and advice of the chief minister. First statement is true. First statement is true. Article 258, clause 2. The delegation of executive powers from the center to the state cannot be done without the consent of the latter. Meaning, center, state governments executive power delegate பண்ணுது with the consent of state. No. State consent இருக்கணுங்கிற அவசியம் இல்லை. Center assign பண்ற delegation state follow பண்ணலனா it is a criteria for imposing recommendation of a president rule. Constitutional framework follow பண்ணலன்னு. So state ஓட consent இருக்கணும்னு இல்லை. Center இதெல்லாம் தான் state ஓட executive delegations எதெல்லாம் delegate பண்ணுதோ அது யார் follow பண்ணி ஆகணும்? State governments follow பண்ணி ஆகணும். So cannot be done with the concern of later. Later யாரை பத்தி பேசுது? State பத்தி பேசுது. No. அப்படியே அந்த directions of central government follow பண்ணாது தானே is one of the ground for imposition of recommendation of the president rules in state. So second statement is wrong. First statement is true. So answer correct. One only. A. Both. First dama correct. Second one tappu. Cannot be done. Without the consent the statement. Cannot be done. Okay. Rajmanna Commission, Sarkaria Commission and Panchi Commission. Center-state relations. Possibility are there because Tamil Nadu has recently formed a 3-member committee. Okay, consider the following statement regarding Interstate Council. It is a constitutional body under Article 263. The Union Home Minister is the ex officio chairperson of the council. Yaradu? Prime Minister. Its decisions are generally taken by consensus among its members. Yes. So the answer would be only 2 statements, 1 and 3. Second statement is wrong. A state legislature, with the prior recommendation of President, can impose restrictions on trade and commerce within a state in public interest. Yes, the state legislature can impose reasonable restrictions on trade with the recommendation of President. அது அந்த reasonable restrictionsங்கிறது தான் elaborate பண்ணியிருக்காங்க in the interest of public. Public interest இருந்தா trade and commerce within the stateல restrictions impose பண்ண முடியும் state legislatureால. So this is true. First statement is true. The parliament cannot give preferential treatment to one state over the other in trade and commerce under any circumstances. No. Again, declares in public interest nala we can give differential statement treatment to the states. Article 303 இது Article 304B. So the answer is 1 only. Reasonable restrictions, again public interest. The Constitution of India explicitly provides for which of the following duties to be performed by center in relation to the states: to preserve the existing boundaries and the territorial integrity of the states, to protect the state against internal disturbances. Yes. To provide financial assistance to all the states. No, no. To ensure the government in the states is being carried in accordance with the Constitution. Yes. To protect the interest of the state at the union level. No. இதுவும் வராது. Explicitly வராது. No. Preserve the existing boundaries and the territorial integrity of the states கிடையாது. Center நினைச்சா எப்ப வேணா boundaries and the states diminish area diminish பண்ணலாம், increase பண்ணலாம், இல்லனா name கூட alter பண்ணலாம். So say first one wrong, financial assistance to all state wrong, அதுவும் wrong. Option என்ன அப்போ? 2 and 4. B, option 2 and 4. Question number 20, statement 1. India is a quasi-federal state. Yes. The Parliament of India can change the boundaries of state only with their consent. No. Option 1 is correct, 2 is false. Enga. C. Question number 21. The governor of a state cannot assign executive functions of the state government to the central government. It can. The President of India can delegate the executive function of central government to the state without the consent of the concerned state government. Yes. So, option? Two only. Option B, 2 only. Consider the following statement with regard to the Central Bureau of Investigation. The state government does not have an absolute power to withhold the consent for CBI probe. State government ku power கிடையாதா? The state government does not have an absolute power to withhold the consent for CBI probe. Consent for CBI probe is different from coordinating or helping the CBI investigation. So, on the probe ku consent state government ala வேண்டான்னு சொல்றதுக்கான ரைட்ஸ் இருக்கா இல்லையா? They have power. They have power. So, they have power. இதுல keyword என்ன? Absolute power. They does not have absolute power னு கொடுக்குறாங்கல்ல, that makes the statement wrong. They have the power, they do not have an absolute power. Once granted, enappa? The state have power to withhold. Idan actual. State can have power to withhold. Initially. அதுக்கப்புறம் directions வருது அப்படின்னா அதை அவங்க ஃபாலோ பண்ணி தான் ஆகணும். ஸோ ஃபர்ஸ்ட் ஸ்டேட்மெண்ட் இஸ் ராங். என்ன சொல்ல வரேன்னு புரிஞ்சுக்க முடியுதா? தே ஹாவ் பவர் டு வித்ஹோல்ட். அந்த அப்சல்யூட் பவர் இன் தி செகண்ட் இன்ஸ்டன்ஸ், அதாவது when they redirect from the court. ஃபர்ஸ்ட் ஸ்டேட்மெண்ட் ராங் தான். ஃபர்ஸ்ட் ஸ்டேட்மெண்ட் இஸ் wait, என்னது? State does not have an absolute power. True. Absolute power இல்லைன்னு தானே கொடுத்துருக்கு. They have power to withhold, but they do not have an absolute power. Fine. So first statement is correct. Once granted, the state government cannot withdraw its consent for a CBI probe. Wrong. This is wrong. First statement true, second one wrong. Option C. This is last class. Asymmetric nature of Indian federalism. Read down the options, give me the answer. We have federalism, but not all states are treated equally. Constitutionally, there are some provisions which make some biases in the states. So identify them. Establishment of union territories with legislative assemblies. Yes. Establishment of 5th and 6th scheduled areas. Granting special category status to the states. Granting equal legislative powers with all the union territories. No. 4 varadu. 1, 2 and 3. Okay, consider the following. The center is empowered to give directions to the state with regard to the exercise of their executive power in how many of the above matters? Maintenance of means of communication of national importance. Provisions of adequate facilities for instruction in the mother tongue. Measures to be taken for the protection of railways outside the state. Drawing up of the schemes for the welfare of scheduled tribes. All 4. Article 357, 350A, again 357, 339. So all are constitutionally enshrined, all 4. The center is empowered to give direction to state. Article 257. 257, 350A. 357. சொல்லிட்டேனா? ஓ 339. இது 5 5 357. இது ரெண்டும் 357. 350A, 339. Okay. Again, regard to Interstate Council, established under Article 263. Its organization and duties are defined by the President of India. Its decisions are binding on matters concerning a legal controversy in the interstate disputes. Which of the statements is or are correct? 1, 3. Organization and duties are defined by the President of India. True. It is chaired by Prime Minister, but their functions are defined by President. Second statement is true. Interstate Council is an advisory body. Its decisions are non-binding. So the answer would be 1 and 2. Option B, 1 and 2. Consider the following statement with regard to the federalism in India and in USA. In both countries, governors in state are appointed by the president. In both countries, upper house has representation from states based on population. In both countries, the states cannot propose an amendment to the constitution. Governor அங்க எப்படி appoint பண்ணுவாங்க USAல? They are directly elected by the people. So, Indiaல தான் governors are appointed by the president. USல governors are directly elected by the people. So, first statement is wrong. In both countries, the upper house has representation from the states based on population. They have equal representation. For every state, regardless of the population, 2 members would be present in the upper house. Namakku da, based on population, the seats proportion has been adjusted. So, second statement is also wrong. In both countries, the state cannot propose an amendment to the constitution. நம்ம propose பண்ண முடியுமா amendment? No. They could not propose the amendment directly, but proposal பண்ண முடியும். நமக்கும் constitution amendment change பண்ண முடியுமா? Through legislative processes. Similarly, both countries cannot propose an amendment to the constitution directly. They need some legislative approvals. Third statement is the only true statement. So, answer is only 1. Borrowing power of center and states. Regarding the borrowing power of center and states, the central government can borrow either within India or outside upon the security of Consolidated Fund of India. Yes, Consolidated Fund of India backup la vechi dhaan state kulliyum kadan vaanga mudiyum illana outside liyum. State public sector enterprises can directly borrow from the external bilateral funding agencies. State public sector enterprises can directly borrow from. No. Directa borrow panna mudiyadu. A state government having an outstanding loan from the center cannot raise any loan without the consent of the center. Yes. Outstanding irunda avanga consent illama raise panna mudiyadu dhaan. So the answer is 1 and 3. Enga irukku 1 and option D, 1 and 3. Statement regarding president's rule. Once the president rule is declared in the state, its legislative assembly gets dissolved. Or it is kept under suspension. Not always. Automatically dissolved ingra concept varadu. Once imposed, it can continue indefinitely without any approval from the parliament. No, maximum of 3 years. President rule has a maximum time period of 3 years. Upon approval, every 6 months. Every 6 months. Okay. So answer enna? Neither 1 nor 2. Option D. Which of the following provisions were added to the Constitution of India via 44th Constitutional Amendment Act? A national emergency can be imposed on the ground of armed rebellion. Yes, internal disturbances was replaced with the term armed rebellion through the 44th Constitutional Amendment. So first statement true. The president can declare national emergency after receiving a written recommendation from the cabinet. Yes, it is also added through the amendment 44th. The president through declaration can revoke a national emergency. The proclamation of emergency can be made for whole of the country or any part of it. Emergency that is proclaimed on the ground of external aggression cannot be challenged in a court of law. Article 5. Proclamation, this was part of the original text. Okay, President can declaration, emergency proclamation cannot be challenged. It can be challenged or it is under judicial review. The judicial review is again inducted by 44th. So the answer is one, two, and 1, 2 only. Provoke a national emergency. These are all part of original text. 1 and 2. Question was regarding not the right statement, but the provisions added from 44th Constitutional Amendment 1 and 2. Okay. Judicial review panna mudiyum. Fine. Answer is 1 and 2. Question number 30. Which of the following situations will the president rule imposed in a state deemed improper? Read the statement and give me the answer. எந்த கேஸ்ல president rule import பண்றது improper-ஆ இருக்கும்? The state government is accused of maladministration or corruption. Corruption is not a ground for president's rule. So first one is wrong. The state government is pursuing anti-secular activities. No, no, no. Improper தான் கேட்டிருக்காங்க. Yes, improper. Anti-secular activities-ல president rule impose பண்றதும் improper. Yes, president rule பண்ண முடியாது. Fine. The governor makes an assessment that the government has lost the majority in the legislature without allowing it to prove majority on the floor of the assembly. Yes, it is also improper. 1, 2, and 3. All three conditions stated are deemed to be improper for the application of president rule. Question number 31. In how many of the above ways can the proclamation of national emergency be revoked? Or national emergency revoke பண்றதுக்கு மேல என்னென்னலாம் conditions? The President of India issues a proclamation for the revocation of emergency. பண்ண முடியுமா? President proclamation பண்ணலாம். 1/10 of the members of Lok Sabha submits a written notice to the President for the revocation of emergency. Lok Sabha இருந்து 1/10 members ஒரு written கொடுத்தாங்கன்னா அது என்ன ஆகும்? They sit for a special sitting which discuss about the revocation. பண்ணலாமா வேண்டாமான்னு அந்த சிட்டிங்க்கு தான், அந்த டிஸ்கஷனுக்கு தான் அது கம்பல் பண்ணுமே தவிர்த்து அந்த ரிட்டர்ன் பண்ணதுனால அந்த ரிட்டர்ன் நோட்டீஸ் இருக்குனால மட்டுமே ரிவோக் பண்ணிட முடியாது. So it will compels for a discussion or a special sitting that must held discussion regarding revocation. Anti-secular activities. அது ஏன் நான் படிக்கும்போது மட்டும் பாலிட்டிக்ஸ் இதெல்லாம் எனக்கு தெரிய மாட்டேங்குது. ஷூரா? சரி, ஓகே. ஆர்டிகல் என்ன சொன்னீங்க? அதுலயே இருக்கா, எக்ஸ்பிளிசிட்டா இருக்கா ஆன்டி செக்யூலர்? சரி, நான் செக் பண்ணிட்டு வரேன். சரியா? கொஸ்டின் நம்பர் 30. Anti-secular is a ground for improper, sorry, ground for president rule, anti-secular activities. Question number 30. ஞாபகம் வச்சுக்கிறேன். The second statement is wrong. Third one, a resolution for the revocation is passed in each house of the parliament by a simple majority. Yes. The Rajya Sabha rejects the proclamation of emergency at a time when the Lok Sabha stands dissolved. Lok Sabha இல்லாத போது Rajya Sabha அந்த proclamationக்கான bill pass பண்ணிருந்தா? Yes. So the answer would be only 3. Second one வராது. Article 360, proclamation of financial emergency. Such a proclamation needs to be approved by the parliament within 2 months. Such an emergency, once approved, continues indefinitely without needing any repeated parliamentary approvals. The courts are allowed to review the grounds on the imposition of such an emergency. Grounds are not allowed. Are allowed. So 1 and 2. Options B. National emergency, Article 352. The president cannot proclaim a national emergency without receiving a written recommendation from the Union Cabinet. Yes, 44th Amendment has brought in this clause. It must be approved by both the houses of parliament within 2 months from the date of proclamation. Yes, it can be revoked by the president at any time without any parliamentary approval. He can revoke. Yes, without any parliamentary approval. All three statements are true. Two months தானப்பா. ஃபினான்ஸுக்கும் பாருங்க, நீங்கெல்லாம் கொஞ்சம் அப்டேட்டடா இருப்பீங்க, கிளாஸ் எல்லாம் போயிருக்கீங்க, நம்பி நான் நிறைய கரெக்ஷன்ஸ் பண்றேன். பரவாயில்ல, நான் பார்த்துட்டு வந்த வரைக்கும் அது 2 months. Earlier it was 2 months. இப்போ 1 month. அப்ப ஆன்சர் என்ன வரும்? ஆப்ஷன் சி. ஆப்ஷன் சி, 1 and 3. 33. Question number 33. Okay, question number 34. Chalo. Statement 1. The President of India can impose the President rule in a state if it fails to comply with directions given by the Union government. Yes. If a state fails to comply with directions given by the Union government, the President may assume that the state government cannot be carried out in accordance with the Constitution. Yes. So, does it correctly explain statement 1? Yes. So, the option is A. Both the statements 1 and 2 are right, and it explains the earlier one. Which of the following can be the consequences of financial emergency in India? The president can mandate the reduction of salaries and allowances of employees of the state governments. The president can require state legislature to reserve all money bills for his or her consideration. The president can issue directions for the reduction of salaries of judges of Supreme Court and High Court. Yes. Is it correct? Bill, reserve all bills. All money bills. Sure. இவ்வளோ கான்ஃபிடென்ட்டாக இருக்கீங்க. சரி, fine. So, where were we? President can require state legislature to reserve all money bills. இந்த ஸ்டேட்மெண்ட் அதோட செக் பண்ணுங்க. கரெக்ட் தானா? சரி, ஓகே. All the above. 1, 2 and 3. Is it a consequence of financial emergency? Financial emergency வந்தா இப்படி சொல்லணும்னு இருக்கா? ஜென்ரலாவே பிரசிடென்ட்டுக்கு கேன் ஃபைன். இவ்வளோலாம் சொல்லும் போது நான் ஒத்துக்கிறேன் பின்ன. Where were we? 36. President rule can be imposed in state in which of the following situations? ஆன்சர் என்ன இதுக்கு? Can be imposed. Corruption வந்து வராதுன்னு இப்பதானே கொஞ்ச நேரத்துக்கு முன்னாடி பார்த்தோம். 3 வராது. 1 and த்ரீ கண்டிப்பா வராது. 3 வராதுனாலே ஆன்சர் வந்து 1 and 2 தானே. 1ம் வராதா? When no party secures a majority after state assembly elections. உங்களுக்கு ஆப்ஷனே அந்த மாதிரி கொடுக்கலையே. எப்படியும் 3 வராது. 3 நான் கேன்சல் பண்ணேன்னா பி. நான் வந்து நெக்ஸ்ட் கிளாஸ் உங்களுக்கு எப்போ? டியூஸ்டே தானே. நான் இதெல்லாம் மறுபடியும் நான் நல்லா படிச்சுட்டு வருவேன். சரியா? எஸ் டியர். கேன் பி இம்போஸ்ட். ஃபர்ஸ்ட் ஸ்டேட்மெண்ட் அப்போ கரெக்ட் தானே? என்னப்பா ஆம்பிகுட்டியாக ஸ்டேட்மெண்ட் வந்து ரொம்ப வேகா தெரியுதா? ஆப்ஷன் உங்களுக்கு கொடுக்கல அந்த மாதிரி 2 ஒன்லின்னு. ஸோ தி ஆன்சர் இஸ் 1 and 2. A national emergency can be declared. Then 1 and 2. Internal disturbance replaced by armed rebellion. 38. Following is not an option available to the president regarding a state bill reserved by the governor. Not an option under Article 201. Option D, amend the bill and send it back to the state legislature. He can give assent, withhold the assent, or direct the governor to return the bill. Amend the bill and send it back to state legislature is not an option. A public bill, if rejected by the House, may lead to the resignation of government as it signifies loss of parliamentary confidence. Yes. A private bill requires only a 7-day notice for introduction in the House and is usually drafted by the concerned ministry. 1 month notice, and also it is not drafted by the ministry, it is drafted by the member, the private member. Public bill தான் என்ன notice கொடுப்பாங்க? 7-day notice கொடுப்பாங்க. இது 1 month notice. So option A, 1 only. Okay. The governor may return an ordinary bill once for reconsideration, but must give assent if it is passed again. Governor, yes. The Legislative Council can only make recommendations on a money bill, and must return it within 30 days. 14 days. Option A, not correct. Not correct. Answer is B, 2 only. இது பார்த்தோம் தானே? Bill lapse. Question number 42. Statement regarding passage of ordinary bill. Read the statement. 42. All 3 statements are true if the council rejects a bill sent by the assembly and the assembly passes the bill again and sends it back. One question. Okay. Read through them. A bill pending in Lok Sabha which was transmitted from the Rajya Sabha. A bill passed by Lok Sabha but pending in Rajya Sabha. Joint sitting of dissolution bill. Read and tell me the answer. 41. Cases, the bill lapse. எதெல்லாம் lapse ஆகும்? One, 2, and 4. ஆவாதா? Bill pending in Rajya Sabha but not yet passed. ஆமா, நான் ஏன் tick போட்டிருக்கேன்? Bill both houses but awaiting bill passed on both. Returned by the bill passed by president but not notified for a joint sitting. Four வராதா? 4 தான் நான் மார்க் பண்ணியிருக்கேனே. 1, 2, and 4. Bill passed by both houses awaiting president assent. ஆவாது. 5, 5th option. A bill passed by both houses. அது lapse ஆயிடுமா? அப்போ do lapse. 1 need 2. Sure. I have encircled 1, 2, and 4 as a key. கண்டிப்பா வராது. நான் போய் செக் பண்ணிட்டு வருவேன் நாளைக்கு நானு. Only 2. A bill on which the president has notified a joint sitting before the dissolution of Lok Sabha. ஆகாது அது. சரி, வில் செக். இன்னொரு டே இருக்குல்ல, ப்ராப்பரா ரிவைஸ் பண்ணிட்டு வருவோம். வேவவி. Option 42, option D, all 3 statements with reference to president role in state bills. 43. 43 and answer enna? The president can give assent, withhold assent, or return the bill for reconsideration. If returned and passed again, the president is constitutionally bound to give assent. No. He is not constitutionally bound, but generally he will. Generally he will. Conventionally he will. He has some veto powers. Panna venda nenachalo, he can pocket the bill also. So second statement is wrong. There is a time limit of 6 months for the state legislature to act on the president's reconsideration request. So answer 1 and 3. State legislature 6 months time limit irukku. So answer 1 and 3. Okay. Which of the following circumstances can the parliament make laws on subjects enumerated in the state list? When the Rajya Sabha passes a resolution supported by 2/3 of member present and voting. Yes, Article 249. During the operation of a national emergency. Article 250. When 2 or more states make a joint request to the parliament. Article 252. When the governor of a state sends a report recommending central legislation. No. 4 varadu. Option 1, 2 and 3. Consider the following statements regarding the institutional and political authority of Prime Minister of India. Prime Minister is the ex officio chairperson of bodies such as Niti Aayog, Interstate Council, National Integration Council, and National Water Resources Council. Yes, the Prime Minister leads national crisis response at the political level, acting as a chief coordinator during emergencies. Both the statements are true. The governor appoints the state election commissioner. 46, question number 46. The governor appoints the state election commissioner who can be removed only like a high court judge. Nani? The governor appoints the advocate general and determines his or her salary. First statement enna? Article 243. 243K. Governor can remove members of the State Public Service Commission. No. Governor appoints the members, whereas removal of the members are by president. So third statement is wrong. 1 and 2. Napa? Correct தானேங்க? அப்ப நானே பசி மயக்கத்துல பாதி தான் தெரியுது. ஆல்ரெடி வேற 30-33 நான் அஜுமா செக் பண்ணிட்டு வருவேன். நெக்ஸ்ட் கிளாஸ் எப்ப பாக்குறோம்? கரண்ட் அஃபேர்ஸ் கிளாஸ் இருக்காது கமிங் சாட்டர்டே. Tomorrow. Personal reasons. I have to leave. So where were we? 47. Question number 47. Significance of DC Vadha case 1987. உங்களுக்கு வேற கரண்ட் அஃபேர்ஸ் நான் தான் இருக்க மாட்டேன். கிளாஸ் இருக்கும், கரண்ட் அஃபேர்ஸ் செஷன் போகும். சரியா? Where were we? 47 ஆன்சர் சொல்லு சட்டன் சொல்லு. Option B. It ruled that the repromulgation of ordinances without legislative approval is unconstitutional. Biharல இந்த கேஸ் நடக்குது. So the option B. Question number 48. With reference to constitutional amendment procedure in India, consider the following statement. Most provisions of the constitution can be amended by a special majority of parliament. Most of the constitutional amendment requires special majority. Yes. The creation or abolition of a state council, a state legislative council, requires both parliamentary approval and prior consent of the president. No. Second statement wrong. The Parliament cannot amend any part of the Constitution that violates the basic structure doctrine. Yes. So the answer is only 2. B, only 2. Question number 49. The 44th Constitutional Amendment Act introduced an article placing the election of Prime Minister beyond judicial review. No, he brought in the ambit of Prime Minister for judicial review, the election of Prime Minister. So, first statement wrong. The Supreme Court of India struck down the 99th Amendment to Constitution of India as being violative of the independence of judiciary. Yes. Formation of NJSC. Beyond. Answer 2 only. Question number 50. In Keshavananda Bharati case of 1973, the Supreme Court of India ruled that right to property is not a basic feature of Indian Constitution. Yes or no? Yes, right to property is not a basic feature. Parliament does not have power to amend any of the fundamental rights of the citizen provided under Part 3 of the Constitution of India. No. Fundamental rights are amend pannalam. When it violates the basic structure and doctrine. So, does not have the power. Illa, idu correct. Answer 1 only. A, 1 only. In India, judicial review implies. Judicial review is brought in to ensure the supremacy of the Constitution rather than Parliament. Option A, the power of the judiciary to pronounce upon the constitutionality of laws and execute orders. As per Constitution of India, every high court shall be a court of record. What does it signify? The decisions and judgments of a high court are recognized as legal precedents in any other lower court of India. A high court has the power to punish for its own contempt. Yes, yes. Court of record. Next, a high court can withdraw a case pending in a subordinate court under its jurisdiction if it involves a substantial question of law that requires interpretation of the Constitution of India. Yes, possible, but it is not under court of record. It is part of supervisory jurisdiction. Correct da. Lower court or higher interpretation தேவைப்படுதுனா அந்த கேஸ high court கொண்டு வர முடியும். ஆனா அது court of recordங்கிற ஒரு பேசிஸ்ல வராது. This is part of supervisory jurisdiction. So for this question, High Court acting as a court of record, first 2 statements are correct. பெரிய ஸ்டேட்மெண்ட்ஸா இருக்கு, சீக்கிரம் படிச்சுட்டு ஆன்சர் சொல்லுங்க. क्वेश्चन 4 லைன் இருக்கு. ஃபைன். The Supreme Court of India invokes Article 142 in exceptional cases where statutory provisions may not be sufficient. Which of the following scenarios best represents the use of 142 by Supreme Court? That is, pass any order necessary to do complete justice. That's Article 142. First one, Supreme Court provides an opinion to the President on whether to impose any timelines for decisions of the President and the Governor on granting assents to bill under Constitution. This is the advisory jurisdiction of Supreme Court, Article 143. Supreme Court transfers a case from a High Court to itself involving a major corruption scandal involving high-ranking officials. 139A, it is also True. The Supreme Court grants special leave to appeal from any judgment or order made by any court in territory of India, Article 136. So 142 la irukkudiya exceptional case number, option number D. The Supreme Court overturns the result of the election for the post of mayor of a municipal corporation. The Parliament of India may by law provide for the creation of all India judicial services if a resolution is passed declaring that it is necessary in the national interest to do so. The resolution to this effect, all India judicial services. First அது எங்க மட்டும் பாஸ் பண்ண எங்க இனிஷியேட் பண்ண முடியும்? ராஜ்யசபா only. So ரெண்டு ஆப்ஷன் எலிமினேட் பண்ணுங்க. It can be introduced in Rajya Sabha only, shall be passed by a majority of its total membership or a majority of not less than 2/3 of its member present and voting. எதா இருக்க முடியும்? ஆப்ஷன் டி. ராஜ்யசபால தான் அதை இன்ட்ரோடியூஸ் பண்ண முடியும். அதே சமயம் not less than 2/3 present and voting. Fall under the original exclusive jurisdiction of Supreme Court of India. Original jurisdiction. கீழே எதெல்லாம் வரும்? A conflict between union government and state government regarding our legislative powers. Yes. A dispute between two states over the alignment of their common boundary. Yes. An appeal against Election Commission's order disqualifying a member of parliament. No. This is under the High Court. Article 329. So answer 1 and 2. Consider the following, which have been identified as quasi-judicial bodies in India. National Consumer Disputes Redressal Commission, Central Information Commission, Election Commission of India, Quasi-judicial. Election Commission is a constitutional body with the regulatory and supervisory powers rather than judicial powers. Election Commission election petition regarding disputes regarding election of president vice president na adi anga dhaan kondu pogum, கோர்ட்டுக்கு தான் கொண்டு போகும். So election commission வராதுப்பா. Interstate Council இப்பதானே பார்த்தோம். Interstate councils are not binding, they are advisory of nature, they are advisory bodies, so they also do not enjoy the provisions of judicial nature. So answer is 1 and 2, only 2. எலெக்ஷன் கமிஷனால ஜுடிஷியல் ப்ரொசீடிங்ஸ் இனிஷியேட் பண்ண முடியாதுப்பா. அவங்க வந்து எலெக்ஷன் பெட்டிஷனா கோர்ட்டுக்கு தான் அதை சப்மிட் பண்ணுவாங்க, சுப்ரீம் கோர்ட்டுக்கு தான் கொண்டு போங்க. ஸோ இட் இஸ் அ சூப்பர்வைசரி அண்ட் அட்வைஸ் ரெகுலேட்டரி. அவங்களுக்கு ஒரு சிவில் கோர்ட்டுக்கான பவர் கிடையாது, கோர்ட்டுக்கான எந்த பவருமே கமிஷனுக்கு கிடையாது. இன்டர்ஸ்டேட் கவுன்சில் இட்ஸ் அட்வைசரி. இவங்க ரெண்டு பேர் தான் குவாசி ஜுடிஷியல். Among 4 options, only 2 are quasi-judicial. அவங்க தான் ரிசால்வ் பண்ணுவாங்க, ஆனா அது ஜுடிஷியல் கேட்டகரிக்குள்ள வராதுல. அதான் என்ன கன்ஃபியூஸ் பண்றீங்க. ஏதோ நான் உங்க பாலிட்டிக்ஸ் டீச்சரா இல்லாதனால தப்பிச்சிடுறீங்க. Let me check. Election Commission as a quasi-judicial. இருக்கா quasi-judicialனே இருக்கா? லக்ஷ்மிகாந்த்ல இருந்தா நான் ஒண்ணுமே பண்ணது அப்புறம் கேண்டிடேட்ஸோட என்னன்னா அது ஜுடிஷியல் ப்ரொசீடிங். ஜுடிஷியல்னு அட்ரஸ் பண்ணோம்னா அதுக்கு வந்து ஒரு மெஜிஸ்ட்ரேட்டோட ஒரு மினிமம் பவர்ஸ் ஆச்சும் இருக்கணும். அந்த மாதிரி எலெக்ஷன் கமிஷனுக்கு இருக்கா? என்னடா இது? Option 3. So 1, 2 and 3. கரெக்டாமா? இங்க பாரு, தப்புன்னு நீங்க தான் என்ன கரெக்ட் பண்ணிட்டு இருக்கீங்க. சரி, ஏதோ நிறைய பேருக்கு மெஜாரிட்டி இருக்கிறதுனால நான் கம்முன்னு இருக்கேன். ரெண்டாவது, நான் ப்ராப்பரா படிக்க உட்காரணும். இப்பதானே ஸ்டார்ட் பண்ணிருக்கேன். I took a break of more than 3 years now. என்னப்பா? குவாலிட்டி இல்ல, என்டையர் ப்ரிப்பரேஷன். ஆப்ஷன் ஆல் 3. ஆல் 3 இல்லடா, என்னதான் only 3. Question number 57. In India, prisons are managed by state governments with their own rules and regulations for the day-to-day administration of prisons. In India, prisons are governed by the Prisons Act 1894, which expressly kept the subject of prisons in control of provincial governments, now state governments. The Act pragaram provincial governments, presently state governments. Answer is true. So the answer option A. Napa? Option A. Consider the following statements. First one, if the election of President of India is declared void by the Supreme Court of India, all acts done by him or her in the performance of duties of his or her office of President before the date of decision becomes invalid. No. Becomes valid. Article 71, de facto doctrine. Election for the post of President of India can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. No. It cannot be postponed, suggesting some of the state legislators have elections or dissolved nations. When a bill is presented to the President of India, the Constitution prescribes time limits. He or she has to declare his or her assent. No. Answer? None. None of the above. Question number 59. The Constitution of India explicitly mentions that in certain spheres, the governor of a state acts in his or her own discretion. The President of India can, of his or her own, reserve a bill by the state legislature for his or her consideration without it being forwarded by the governor of the state concerned. No. Explicitly mentioned. One only. Can use suspensive veto. Answer? One. Only one. Money bills, he must give assent. Constitution amendment bill also. There is no veto for these two. Question number 61. Give assent to the bill, withhold assent to the bill, direct the governor of the state to return the bill to state legislature for reconsideration. Enna panna mudiyum? All three. All three anna. இப்ப சொல்லுங்க ஆன்சர். மணி பில் என்ன பண்ண முடியும்? ரிட்டர்ன் பண்ண முடியாது. Only two. Under the provisions of the 5th schedule, which of the following is empowered to direct that any area or part thereof shall cease to be a scheduled area? யார்கிட்ட தான் இருக்கு பவர்? president கிட்ட a president can declare, alter or cease any area as scheduled areas under 5th schedule. So he is the one who can declare, alter and cease. Cease any area. Prime Minister as chairperson. National Medical Commissionல chair பண்ணுவாரா? கண்டிப்பா ஒரு மெடிக்கல் ப்ரொஃபஷனரா தான் இருக்க முடியும். ஸோ பிஎம் இல்ல. National Security Council, yes. Interstate Council, yes. National Disaster Management Authority, yes. Zonal councils, no. Zonal councils are headed by Home Minister. Answer, only 3. Option B, only 3. Not correct. Not correct statement identify பண்ணுங்க regarding Union Government of India. The union government may not entrust a state government with functions over matters where executive powers of the union extends. Wrong. It may entrust the state government. இது லாஸ்ட் கிளாஸ்ல பார்த்தல ட்ரைபல் வெல்ஃபேர் மினிஸ்டர் எந்தெந்த ஸ்டேட்ஸ்ல? சத்தீஸ்கர், மத்திய பிரதேஷ் அண்ட் ஒடிசா. ஆப்ஷன் 1, 2 and 3. 1, 2 and 4. Only 3. With reference to the Joint State Public Service Commission, which of the following statements is or are correct? It is a statutory body. The chairman members of JSPSC are appointed by the President of India. The members serve a term of 6 years or until the age of 65, whichever is earlier. Joint Public Service Commission is a constitutional body under Article 315. Chairman and members are appointed by the President. Yes. அவங்க term and retirement age என்ன? 6 years or until the age of 62, whichever is earlier. So option is 1 only. Option C, 1 only. Correct தானே கேட்டிருக்காங்க? 2 only. 2 only எங்க இருக்கு? None of the above கொடுக்கவா? 2 only is the answer. Two only. இப்படி மாத்திரணும். 2 only. In India, limits of territorial waters, the continental shelf, the exclusive economic zone, and other maritime zones of India shall be specified by the Parliament. Maritime zones are part of Union list. Option A, Parliament. Huh? 60th. என்னதுப்பா? சரி அது இருக்கட்டும். இப்போ அது வேற. வேவவி 66 ஸ்டாட்யூட்டரி பாடியா? ராஜ்யசபால ஃபார்ம் பண்ணலாம். பட் ஸ்கோப் ஆஃப் ஜாயிண்ட் பப்ளிக் சர்வீஸ் கமிஷன் ஆல் இந்தியா சர்வீசஸ் கீழே தானே வரும். ஆர்டிகிள் கீழே தானே வரும். பிரசிடென்ட் கிடையாது, கவர்னரா? ஜாயிண்ட் பப்ளிக் சர்வீஸ் பிரசிடென்ட் தான்ப்பா. It is established under Act of Parliament. இருந்தாலும் அதோட ஸோ அப்போ ஸ்டாட்டுட்டரி பாடின்னு சொல்லும் போது அது கரெக்டாக இருக்குமா? ஸ்டேட்மெண்ட் ஒன் கரெக்டா? அப்போ 1 and 2 இங்கே போகலாமா? ஷோரா? இட் இஸ் நாட் அ கான்ஸ்டியூஷனல் பாடியா? ஆல் இந்தியா சர்வீசஸ் ஆர்டிகல் 315 தானே வருது, ஜேபிஎஸ்சிசி. பட் கிரியேட்டட் பை அன் ஆக்ட் ஆஃப் பார்லிமெண்ட். Resolution shall be initiated in the Rajya Sabha only. ஆமா தானே? Rajya Sabha only. Fine. So option 66 ஓட option A 1 and 2. நான் செக் பண்றேன். Statutory body. என்ன தெரியுமா? I don't prefer லக்ஷ்மிகாந்த். லக்ஷ்மிகாந்த்னு ஒரு ரெடிமேட் புக் இருக்குல்ல, நம்ம வந்து சரி வேண்டாம், வேணாப்பா வேணாப்பா. அதான் எங்க 150 questions பார்க்க முடியுமா? ஐயோ, ரொம்ப ரொம்ப எஸ்பா. இது கேன்சராப்பா. இது வந்து ஃபர்ஸ்ட் ஸ்டேட்மெண்ட் ட்ரூவா. Even though established as an all India services, it is created by an act of parliament, resolution passed by the Rajya Sabha. So statutory body is correct. Statement 1 is true. Chairman appointed by the president. Statement 2 is also correct. Third statement wrong because at the age of 62, whichever is earlier, 6 years or 62. So third matana wrong, இவங்க ரெண்டு பேர் correct. So answer 1 and 2. ஆர்டிகல் 315 கீழே தான் ஆல் இண்டியா சர்வீசஸ் வரும். நீ தான் இதை விட்டுரு நான் சொன்னேன்ல. 31 அதற்கு அந்த ஆர்டிகல் செட்ல தான் இது கிரியேஷன் வரும். என்னவோ புரியல. ஆமா, அந்த ஆர்டிகல் வச்சு கொண்டு வரல. ஃபைன். வைவவி, கொஸ்டின் நம்பர் 68 படிங்க. படிச்சுட்டு ஆன்சர் சொல்லுங்க. ஈஸ்வரா, இதுக்கு ஆன்சர் என்னப்பா? He or she is a member of Interstate Council. Yes, it shall be the duty of Chief Minister of each state to communicate to the governor of the state all decisions of the Council of Ministers relating to the administration of the affairs of the state. All decisions வருமா? Council of Ministers ஓட எல்லா decisionனையும் communicate பண்ணணுமா? Third one, he or she shall make rules for the more convenient transaction of business of the government of the state and for the allocation among the ministers of the said business. இது எக்ஸ்பிளிசிட்டா இருக்கு. ஸோ இதுல கவுன்சில் ஆஃப் மினிஸ்டர்ஸ் இல்ல the so called கேபினட்டோட இம்பார்ட்டன்ட் டிசிஷன்ஸ் ரன்னிங் பர்பஸுக்கு தான் கம்யூனிகேட் பண்ணுவாரு. நீட் நாட் நெசசரிலி ஆல் டிசிஷன்ஸ். ஸோ ஸ்டேட்மெண்ட் 2 வராது. 1 and 3 ஆர்டிகிள் இருக்கு. இது வந்து எக்ஸ்பிளிசிட்டா ஆர்டிகிள் 167ல கொடுத்திருக்காங்க. That the chief minister of each state communicate to the governor regarding the administration of affairs of the state. But all decisions of the council of ministersங்கிறது கொடுக்கல, எக்ஸ்பிளிசிட்டா இல்ல. 167 தானே? என்னப்பா? Option 3. He or shall make rules for more convenient transaction of business of the government of the state and for இல்லையே. Article 166 clause 3. Chief Minister power than 166 clause 3. Governor-ஆ? இது governor-ஆ? அப்ப ஆன்சர் ஒன்னு வரும் 1 and 2-ஆ? 1 and 3 இல்லையா? Article 167 இது வரும் all decisions of Council of Ministers. Two statement correct-ஆ? 1 and 2 correct, 3 wrong-ஆ? Option C 1 and 2. That's 263 interstate. That is fine. He or she shall make rules for more convenient transaction of business of government. Governor oda role. 3 questions irukka. Question number 69. Which of the following committees or commission recommended the abolition of all India services? All India services. Raj Mannar Committee. The committee 1969. It stated that all India services are against the federal spirit, so recommended for the abolition of all India services. Whereas Sarkaria Commission wanted to strengthen the all India services, 1983. Question number 70. Under the provisions of Article 311, which of the following situations can a member of a civil service of the Union can be dismissed or removed without a appropriate inquiry? If the president is satisfied that in the interest of the security of state, it is not expedient to hold such an inquiry. If the authority empowered to dismiss or remove him or her is satisfied that for some reason which should be recorded in writing by the authority, it is not reasonably practicable to hold such inquiry. If that person becomes a member or associated with a political party or joins any organization which takes part in politics. If that person is dismissed or removed on the ground of contact which has led to his or her conviction on a criminal charge. Without an inquiry, dismiss pannakudiya provisions. Except 3, 1, 2 and 4. Option D, 1, 2 and 4. Four, yes pa. ஏன்னா அது ஜுடிஷியல் சப்ஜுடிஸ் கேஸ்ல இருக்கிறதுனால அவங்க ஃபர்ஸ்ட் டிஸ்மிஸ் பண்ணிடுவாங்க. அதுக்கப்புறம் புருவாய் வந்ததுக்கு அப்புறமேட்டி நம்ம பார்ப்போம். எப்படியும் அந்த கன்விக்ஷன் ஆஃப் அ கிரிமினல் சார்ஜ் டிஸ்மிஸ் பண்ணிடுவாங்கப்பா. they are deemed to dismiss without an inquiry. 4 வரும். பட் சும்மா எல்லா கொஸ்டினும் இந்த மாதிரி டவுட் கேட்டிருந்தீங்க பொழந்துருவேன் நான். Question number 71. Money bills, parliamentary. The definition of money bill is provided in the Constitution. Rajya Sabha can amend the money bill. No, they can only recommend. 110 provides definition for a money bill. So answer 1 only. In the context of parliamentary proceedings in India, which of the following types of questions during question hour requires an oral answer from the ministers? Idu nethe paathirom. So answer: starred and short notice. Unstarred demands a written answer. Only 2. With reference to the resolutions in the Indian Parliament, consider the following statements. A member who has moved a resolution or amendment to a resolution can withdraw it without the permission of the House. They cannot withdraw without the permission of House. So first statement is wrong. All resolutions are subjected to voting and may be adopted or rejected. Yes, 2 only. Answer: prior recommendation of President, 74. Question number 74. All. 117 clause 1, 304 clause B and article 3. Answer 1, 2, 3. No, which. 117 clause 1, 304 clause B and article 3. Question number 75. The Constitution of India does not prescribe a time limit for the governor to assent a bill passed by the State Legislative Assembly. Article 368 of Indian Constitution, Constitutional Amendment Bill cannot be introduced in state legislature. Yes, both the statements are true. Panchayat elections. The superintendent's direction and control of the preparation of electoral rolls and the conduct of all elections to the Panchayat is vested in the State Election Commission. The state legislature is authorized to make provisions with respect to all matters relating to elections to the Panchayat, subject to constitutional provisions. Yes, both the statements are true. Consider the following statement. Read through the statements. The Constitution provides for the reservation of not more than 1/3 of the total number of seats for women. Not less than 1/3 of the total number of officers of chairpersons in the Panchayat at each level shall be reserved for women. Currently, 21 states and 2 union territories have made provisions in their respective state Panchayati Raj acts or rules for 50% reservation of women in panchayats. First one wrong. It's not more than 1/3 of the total number. It is not less than 1/3. Option B, 2 and 3. Question number 78. Direct elections to the post of chairperson of panchayats at all levels. Giving representation to the chairperson of the village panchayats in the intermediate levels. Granting financial powers to the panchayat. Fixing tenure of 5 years for panchayat at all levels. How many of the above provisions are compulsory under 73rd Constitutional Amendment Act 1992? Here, direct elections to the members of panchayat need not necessarily the chairperson. So first statement is wrong. 2, 3, 4. Only 3. 3 statements are true. First statements, panchayat members at all levels. Direct elections. Question number 79. Last class also I made a mistake about this. It is Goa, which has 2 tier. Sikkim has 3 tier. So the answer is only 4. Because by convention, the population is below 20 lakh. Question number 80. இன்னொரு செஷன் கூட கொடுக்க மாட்டாங்களே. எங்க கொடுப்பாங்க எங்க இருக்கு டைம் Question number 80 answer the governor has discretion to recommend the imposition of president rule as per the constitution of India in certain cases the governor of the state may act independently from the constitution of the state council of ministers yes option A ஆன்சர் பண்ணுங்க எப்படி ஆன்சர் உங்க ஆன்சர் மாறும் இதுல the chief minister of the state gives advice to the governor on which of the following matters to prorogue or summon the session of the state legislature on decision of dismissal of state minister on disqualification of a member of the legislative assembly under the 10th schedule no the speaker on decision of dismissal of state minister only on the advice of chief minister so the answer is 1 and 2 question number 82 answer என்ன The word socialist and secular were added to the preamble in 1976 through a constitutional amendment. Yes, the preamble cannot be amended to affect the basic structure of the constitution. The preamble can be amended without affecting the basic structure of the constitution. So second statement is wrong. First statement is true. எங்க அது option cannot be amended to affect the basic structure. The correct தான். So it explains this. Yes or no? Explain ஏன் பண்ணல socialist secularங்கிறது basic structure affect பண்ணல அதனால amend பண்ணோம் அதுதானே அந்த statement ஏ இங்க பாரு why are you people doing this to me option is A any doubts ask your polity mentor affecting the basic structure and upholding the basic structure same or not னு பாருங்க எனக்கு தெரிஞ்சு it sounds much more convincingly option A வரட்டும் geography and environment வரட்டும் அந்த வாரம் I am waiting okay ஜாலி முடிஞ்சிச்சா ஏன்டி இப்படி பண்றீங்க question number 83 Article 34 provides for the restriction of fundamental rights while martial law is in force in any area within the territory of India. Article 34 deals with the martial law and the restriction of fundamental rights. So, one true. The Constitution defines martial law as the suspension of ordinary law and the government by military tribunals. Constitution explains, but it does not actually define martial law. A declaration of martial law also results in the suspension of habeas corpus. No, wrong. Third statement is wrong. Second statement is also wrong. The answer is one only. See, basic structure of constitution affect பண்ணாம preamble amend பண்ணலாம் இல்லையா அதானே இது அது என்ன அர்த்தம் preamble amend பண்ண முடியாது எப்போ basic structure affect பண்ணுச்சுனா அப்ப basic structure affect பண்ணலனா preamble amend பண்ணலாம்ல அதானே பண்ணிருக்காங்க socialist and secularங்கிற ஒரு amendment preamble add பண்ணதுனால நம்மளோட basic structure and doctrine எந்த வகையிலுமே அடிபடலல்ல கரெக்டா தானே பேசுறேன் நானு ask you sir இல்ல கன்வின்ஸ் ஆகல உங்களுக்கு டவுட்டா இருக்குன்னா உங்க சர்ட்ட ஒரு தடவை கிளாரிஃபிகேஷன் வாங்கிக்கோங்க. வேற ஆப்ஷன் கொடுத்தாருன்னா அது கண்டிப்பா கிளாஸ்ல வந்து சொல்லுங்க. I stick with option A for that particular question. 84. 84. A private member in a parliament can introduce a constitutional amendment bill, while a money bill can only be introduced by a minister. Yes, money bill can be only introduced by a minister with the prior recommendation of president. Private members bill have never been passed in the Indian parliament. No, it is much more rare occasion, but there are approximately 14 bills since independence. Another never. Correct தானப்பா? Answer 1 only. 85. This is a beautiful question. Try to answer. நமக்குதோ பஞ்சாயத்து வரும். நம்ம என்னன்னு பாருங்க. Question number 85. Assertion and reasoning type of question. Secularism as a basic feature of Indian constitution means that the state remains neutral and does not favor or discriminate against any religion. True. Assertion is very true. Reason. One of the directive principles of state policy states that it will be part of the duty of the state to improve the breeds of cattle and prevent the slaughter of cows and calves. இதுவும் correct, இதுவும் correct. But it does not correctly explain A. So the prevention of cow slaughter is to improve the breed of the cattle. This is more of an agricultural and animal husbandry, not secularism. Okay, so option B. Both A and R are true, and it's not correct explanation of A. Separation of power between executive and judiciary is all the above. 86, all the above. How many of the above have been held by Supreme Court to be part of basic structure of the Constitution? Basic structure of the Constitution. Welfare state, dignity of the individual, integrity of the state, parliamentary privileges. Welfare of the state, dignity of the individual, integrity of the state. 1, 2, and 3. Need not necessarily the parliamentary privileges falls under the ambit of basic structure. So 1, 2, and 3. Only 3. இது நேத்து பார்த்த நேத்தா முந்த first day பார்த்த question. Introduced by Government of India Act. Which are the following provisions? Bicameralism in all provinces வராது. So 1, 2, and 4. Question number 89. Parliament has enacted the Interstate River Water Disputes Act 1956 for dispute resolution relating to waters of interstate rivers. Yes. Water is under the Union list subject of the 7th schedule of Indian Constitution. No. Water is under state list, but the interstate water disputes are covered under union power, the power of union, interstate water disputes. So statement 2 is wrong. First one is correct. Question number 90. Parliament may by law empower any court to exercise the power to issue writs within the local limits of its jurisdiction. Article 32 to 26 talks about the writ jurisdiction of Supreme Court and High Court respectively. Does Parliament have the authority, or Parliament can empower any court? Yes, yes. They have by power empower any court to exercise power to issue writs within local limits or its jurisdiction. Parliament-க்கு அந்த power இருக்கு. The right to constitutional remedies guaranteed by the Constitution of India cannot be suspended at any situation. Emergency, national emergency, there are suspension of fundamental rights. So second statement is wrong. First statement is true. Even though explicitly High Court and Supreme Court have a constitutional writ jurisdiction, Parliament has power to entrust in some other subordinate courts also. So first statement is true, second false. Identify the non-correct statement. B, 2 only. Answer. With reference to the above statements, how many of the above provisions illustrate Indian Constitution has established a strong center? All three. All three. Question number 92. So centers regulation on states borrowing. So first statement is true. The central government can impose annual net borrowing ceiling on certain Indian states to regulate their borrowings. Article 293 article is also true. Empowers the central government to impose restrictions on any type of borrowings by any state in India. 150. சரி 100 questions பார்த்துட்டு கிளம்பலாமா இல்லனா? I asked for an extra session. You can take extra time and complete of as many questions possible. So I took 150 questions. Break. வரட்டும். யார் கோஆர்டினேட்டர் யார் இந்த கிளாஸுக்கு? பிரபா தானே? எல்லாத்துக்குமே அவன் தானே. Question number 93. Answer. Question number 93. Sarkaria Commission was constituted in 1983 to address the growing concerns related by center-state relations. In this context, which of the following not recommended by Sarkaria? Option D. Discontinuation of three-language formula in education to avoid center-state conflicts on this issue. So language issues உள்ள எடுத்து வரல. அதுக்கு முன்னாடி இதெல்லாமே recommend பண்ணாங்க. Strengthening of all India services, setting up of a permanent interstate council under Article 263, and appointment of eminent person who is from outside the state as governor of the state. These are all recommendations of Sarkaria Commission. 94. Option D, the governor of the state with the consent of government of India. Question number 95. Consider the following statements regarding provisions related to grants from the Union to certain states under Article 275 of the Constitution of India. The Union can grant aid to states for any public purpose which may not be mentioned in any existing statute. No, not for any public purposes, for specifically for tribal welfare and development of scheduled areas. Tribal welfare and development of scheduled areas. They are given to states based on the recommendations of Finance Commission. Aid to states are given on the basis of recommendations of Finance Commission. Yes. Second statement is true. First statement is false. Answer 1 only. True only. 2 only. 2 only. Only one statement in my mindset. Next one. 42nd Constitutional Amendment Act 1976 transferred which of the following subjects from state list to concurrent list of the 7th schedule? In the list state and concurrent மாத்துனது. Forests, protection of wild animals and birds, 1 and 3. No, 1, 3 and 4. Social security and social insurance. 1, 3 and 4. Newspapers, books and printing presses, they remained in the union list. Maintenance of land records, they remained in the state list. 1, 3 and 4. Option D. '97. The Parliament can make laws on matters listed in the state list if the Council of States passes a resolution to that effect. In this context, which of the following statement is correct? Such a resolution is considered as passed if it is supported by majority of the members who are actually present and voting. In the majority, it is 2/3 of majority. Special majority of members who are present and voting. Once passed, such a resolution remains in force for a maximum period of 1 year. This provision does not restrict the power of the state legislature to make laws on the same matter. Correct, true. Even though Parliament passes a resolution, state also has power to legislate on the same matter. C, the correct answer. Last option. Laws enacted by the Parliament through such a resolution remain valid after the expiry of the resolution unless repealed by respective state legislation. No, unless repealed by Parliament. So 97, the options is C. 98. During the president's rule in a state under 356, the state legislature assembly dissolved by which of the following authority? Who will dissolve? If dissolved or suspended, it can be done only by the president. President. Panchayati Commission on Interstate Relation has recommended the disposal of a bill reserved for the consideration of Union Executive within 6 months. A state legislature introduces a bill that imposes taxes on the consumption of electricity by the government of India in the state. In this context, which of the following statements given below is correct? Option B. When Parliament by law authorizes the same, only then the state legislature can pass such a bill. Option B. இன்னும் ஒரு 50 questions இருக்கு. உண்மையிலே இந்த questions நல்லா இருக்கு. Constitutional bodies, non-constitutional bodies. இந்த டெக்ஸ்ட் இருக்கா கீ மட்டுமாச்சும் சொல்லட்டுமா? வேண்டாம், நாங்களே பார்த்துக்கிறோம். எப்படியும் நிறைய மிஸ் மேட்ச் ஆகுதுன்னா. चलो यार. என்னப்பா 10 வரைக்கும் கொண்டு போலாமா? Question number 1. Evavi. சரி 15 minutes இருக்கு. முடிஞ்ச அளவுக்கு questions பார்த்துட்டு 10 o'clock ஷார்ப்பா விட்டுறேன். Okay, right on. See, listen. With reference to public interest litigations in India, consider the following statements. The requirement of locus standi has been relaxed for filing of PILs in India. Direct personal interest தான் locus standi அர்த்தம். அஃபெக்ட் ஆனவங்க மட்டும்தான் பண்ண முடியும்னு கிடையாது. யார் வேணாலும் பண்ணலாம். So it has been relaxed for filing PILs in India is true. First statement is true. The Supreme Court of India cannot initiate a PIL on a suo motu basis. False. Supreme Court can also take cases suo motu. Okay, PIL எடுத்துக்க முடியும். So this is wrong, this is true. They cannot be filed in any court lower than high courts. Wrong. They can be filed in other subordinate courts also. So the answer is one only. Locus standing at the direct personal interest. Aggrieved person மட்டும்தான் இல்ல, to third party கூட PIL raise பண்ணலாம். Consider the following statements. The judges of high courts are administered their oath of office by the governor. It's not the president, it is the governor. The salaries and pensions of the high court judges are charged from the consolidated fund of states. Only the pensions are from the consolidated fund of states. Salaries are charged from consolidated fund of India. A judge can be transferred from one high court to another only after consulting the governors of both the concerned states. Salaries வந்து yes, my bad. Pensions are from consolidated fund of India. Yes, yes. Judges can be transferred from one high court to another only after consulting governors of both the concerned state. No, after consulting with the Chief Justice of India. It is not the governors, it is the Chief Justice of India. So, idun tappu, option, only one statement. A. With reference to high courts in India. எல்லாமே தப்பா ஃபர்ஸ்ட் என்ன ராங் போடும் சரி மாறுது okay none with reference to high courts consider the following statement. The numerical strength of judges, numerical strength, okay, high court is determined by the president. The territorial jurisdiction of high court is coterminous with the territory of the concerned state. Numerical strength is by the president, article 216. Territorial jurisdiction க்கும் ஸ்டேட்டுக்கும் co-terminusனு கொடுத்திருக்காங்க, அதுக்கான அவசியம் இல்லை. Mostly the northeastern states, Guwahati High Court acts as the high court for most of the states. லக்ஷதீப் ஐலண்டோட high court எங்க இருக்கு? கொச்சி high court. அந்தமான் நிக்கோபார் ஐலண்ட்ஸுக்கு Kolkata High Court. Even though the state which is closer to Andaman Nicobar is Tamil Nadu. Fine. Question number 4. Question number 4. Answer. One only. An aggrieved person can approach the court with a review petition as a matter of right. It is the discretion of the court whether the review petition has to be admitted or not. And the review petition எடுத்துக்கலாமா வேண்டாமான்னு அது யார்கிட்ட கையில தான் இருக்கு? கோர்ட் கையில தான் இருக்கு. என்னோட ரைட் அதுன்னு போய் நம்ம அப்ரோச் பண்ண முடியாது. So first statement is wrong. Not as a matter of right. The review petition is the court's discretion. The court generally does not allow oral hearings or arguments by the lawyer for a review petition. Yes, it is true. Does not allow oral. Written petitions தான் கொடுப்பாங்க. Written petitions தான் எடுத்து அவங்க கேஸ் திரும்ப ரீகன்சிடர் பண்ண பாப்பாங்க. ஓரலா பண்ண மாட்டாங்க. Second statement is true. Does not allow oral hearings. It is the final judicial remedy available to a petitioner. தீர்ப்பெல்லாம் வந்த பிறகு ரிவ்யூ பெட்டிஷன் அப்படிங்கிறது தான் ஃபைனலா இருக்க முடியுமா? இல்ல. Once, even though the review petition is dismissed, there is a concept of curative petition. So it is not the final judicial remedy. If review petition is dismissed, they can go for a curative petition. அப்போ ஃபைனல் ஜுடிஷியல் ரெமடிங்கிற தேர்ட் ஸ்டேட்மெண்ட்டும் தப்பாயிடும். ஃபர்ஸ்ட் ஸ்டேட்மெண்ட்டும் தப்பு, செகண்ட் ஸ்டேட்மெண்ட் தான் கரெக்ட். ஸோ த ஆன்சர் இஸ் ஒன்லி ஒன். கரெக்டாக தானே எழுதியிருக்கேன்? 1 தப்பு, 3 தப்பு. Question number 5. With reference to writ jurisdictions of court, consider the following. The Parliament can empower any court within the territory of India to issue writs. Yes. So besides High Court and Supreme Court, யார் எந்த கோர்ட்டுக்கு வேணாலும் இந்த பவரை எம்பவர் பண்ணலாம் Parliament. Yes. Writs in India can only be issued for the enforcement of fundamental rights. No. Other legal rights. Along with fundamental rights, other legal rights. So only makes the statement wrong. First one true. Answer one only. Consider the following statements regarding Supreme Court. The Constitution of India declares Delhi as the seat of the Supreme Court. Yes. Article 130, it explicitly declares Delhi as the seat of Supreme Court. Only the Parliament can provide for additional benches of Supreme Court in different places of the country. No, it is the Chief Justice of India with the President's approval. The Supreme Court of India was constituted on 26 January 1950. Yes, yes. Answer is 1 and 3. Correct, then correct. Which of the following comprises the collegium for the selection of Supreme Court judges in India? Read through and give me the option. The collegium system of Supreme Court comprises of option B, Chief Justice of India and 4 senior most judges of Supreme Court. Question number 8. Which of the following fall under original jurisdiction? The original jurisdiction of Supreme Court. Matters involving the election of Speaker of the Lok Sabha? No. Disputes between central and state governments? Yes. Enforcement of fundamental rights of a citizen? Original jurisdiction கீழே வருமா வராதா Supreme Court original jurisdiction? வரும். Article 32, Article 131 ரெண்டுமே வரும். 2 and 3. Regarding the procedure for removal of Judge of Supreme Court of India. A Judge of Supreme Court can only be removed on the grounds of misbehavior and incapacity. The presiding officer of the House cannot refuse to admit a motion meant for the removal of judge. He can refuse. He can refuse if it does not met the requirement. And the requirement இல்லாம எடுத்த ஒரு இதுக்காக கேஸ் கொடுத்தாங்கன்னா இதை எடுக்க முடியாது. So he can refuse if the requirements are not met. A judge can be removed only if a motion is passed by both the houses of Parliament by a special majority. The resolution passed by the Parliament for removal of judges must be addressed to the President during the same session only. Yes. All others are true. 1, 3 and 4. Option B. For becoming a judge of High Court in India, how many of the above qualifications need to be fulfilled by an individual? Should have achieved a minimum age of 35 years. Minimum age னு ஒன்னு prescribe பண்ண கிடையாது. should have held a judicial office for at least 5 years in the territory of India. Judicial office at least 10 years. Should have been an advocate in the High Court for 10 years. 10 years. Advocate for 10 years. Third statement true. Should be a distinguished jurist in the opinion of the President of India. Yes, Anna, this clause is for a Supreme Court judge. Distinguished jurist. And the jurist clause yadhukku apply agade High Court ku varadu. So answer only one. Option A. Question number 11. The Parliament is empowered to provide for the use of any language other than English to be used for the proceedings of the Supreme Court. The Parliament is empowered to provide for. What is the official language for all the proceedings and acts carried out in the court? English. Supreme Court la English. Adu initial 15 years க்கு தான் கொண்டு வந்தாங்க. அந்த amendment கொண்டு வந்த பிறகும் amendment என்ன extend பண்ணிச்சுனா the use of English language as the official language. Parliament can empower. First statement is wrong. The governor of a state can authorize the use of Hindi or any other language in the proceedings of High Court. Second statement is true. Supreme Court la mattum da endha language mattum? English. Article 348. Governor of a state Hindi illana வேற ஏதாவது languageல கூட High Court proceedings கொண்டு போலான்னு கொண்டு வந்தாங்க. That is true. எங்கனா அப்ப answer 2 only. Option 2 only. The expression complete justice in the Indian judiciary refers to the power of Supreme Court to pass an order necessary to ensure substantive justice. Again, original jurisdiction of Supreme Court. Ennala varum? Dispute regarding the enforcement of fundamental rights. Dispute arising out of any pre-constitutional treaty. Dispute between two or more states. Dispute between Government of India and one or more states. Dispute arising out of any pre-constitutional treaty does not covered under your original jurisdiction. Pre-constitutional treaties. So, except 2, 1, 3 and 4. Option C, only 3. Question number 14. Which of the following statements is or are correct with regard to senior advocates of Supreme Court of India? They are designated as senior advocates by Chief Justice of India. They are designated as chief advocates by the Supreme Court of India. They are not by Chief Justice. The court itself designates them as the senior advocates. They are only allowed to appear in the Supreme Court with an advocate on record. Yes. They are entitled to file any matter or document before Supreme Court. They are not entitled. The advocate on record, whom with they are allowed to appear, they will file the matter. So they cannot directly file the matter or document. So idhum tappu. 2 only. Following statement with reference to Legal Services, Supreme Court Legal Service Committee. It aims to provide free and competent legal services to the weaker sections of the society. The Attorney General is the ex officio chairperson of the committee. No. The committee is chaired by any sitting judge. Any sitting judge of the Supreme Court would chair the committee. It is not the Attorney General per se. So one only. சரி போங்க. 15 answers மட்டும் சார் அனுப்ப சொல்றேன் நான். சரி வேண்டாம். என்னப்பா கம்ப்ளீட் பண்ணிடவா? பாரு சும்மா ஏபிசிடி நோட் பண்ணிட்டு போறதுக்கு இல்ல. அவன்கிட்ட தான்டா பேசுறேன். Question number 32 அனுப்பு. 32. Recent statistics data. அதனால இந்த question மட்டும் நான் அட்ரஸ் பண்ணிட்டு போங்க. Question number 32. வீட்டுக்கு போய் கண்டிப்பா ஆன்சர்ஸ் பார்க்கணும். சரியா? ஆன்சர் இது கரெக்டா ஆன்சர் பண்ணா வீட்டுக்கு போயிடலாம். இல்லைன்னா எல்லாரையும் உட்கார வைப்பேன் நான். ஆமா. The representation of women has increased compared to the 17th Lok Sabha. பழைய லோக் சபா விட இந்த புதிய லோக் சபால விமனோட ரெப்ரசன்டேஷன் இன்க்ரீஸ் ஆயிருக்கா? 19th லோக் சபால ரிசர்வேஷன்ங்கிற கான்செப்ட அப்ளை பண்ண போறோம். நம்பர் ஆஃப் விமனோட என்ன கேட்டிருக்கு? டேய் இல்லாதது. ஆன்சர் ஃபர்ஸ்ட் ஸ்டேட்மெண்ட் ட்ரூ. First statement true. Number of women representing in the parliament has increased from the earlier Lok Sabha. More than half of the newly elected members of parliament have been elected for the first time to the Lok Sabha. Meaning, இதான் Lok Sabha members na பாதிக்கும் மேல majority first time elect ஆகி வந்தவங்களா? No. Re-elected members தான் mostly அதிகம் இருப்பாங்க. Third statement, the proportion of MPs who have completed undergraduate education has increased compared to the 17th Lok Sabha. படிச்சவங்க பட்டம் வாங்கணும் இந்த லோக் சபா அதிகமா இருக்காங்களா? இல்ல, it has been decreased. 17th Lok Sabha 27%. 18th Lok Sabha it is 21. என்ன ஆப்ஷன் இல்ல? ஆப்ஷன் இல்ல, பட் இதான் ஃபேக்ட். அதனால தான் இந்த கொஸ்டினை கொஞ்சம் பார்த்துட்டு போங்கன்னு சொன்னேன். கொஸ்டின் நம்பர் என்னது? 32 has decreased. 11th Lok Sabha அப்புறமேட்டி இந்த படிச்சவங்க நம்பர்ஸ் இன்க்ரீஸ் ஆகவே இல்லை. இட் இஸ் கெப்ட் ஆன் டிக்ரீசிங். 11th Lok Sabhaனா 1998க்கு அப்புறம் நம்ம பார்லிமெண்ட்ல படிச்ச எம்பிஸோட நம்பர்ஸ் குறைஞ்சிக்கிட்டு தான் இருக்கு. கிரிமினல் நம்பர்ஸ் தான் டேட்டா ஃபேக்ட் இது. ஓகே, வெயிட் ஒன் மோர் கொஸ்டின் அண்ட் யூ கேன் லிவ். சிம்பிள் கொஸ்டின் தான் இது. எனக்கு தெரியுமே அப்படின்னு உங்களுக்கு தோணும் அந்த மாதிரி. கொஸ்டின் நம்பர் 48. ஆமா, நம்பர் தயவு செஞ்சு படிங்க. ஹேட் ஸ்பீச், ஐடி ஆக்டோட அமெண்ட்மெண்ட் எல்லாமே இருக்கு இதுல. चलो, try to answer question number 48. CAG, Vice President, Judges of Supreme Court, candidates for the election of Parliament, Governor of a state. How many of the above do not have their oaths of office? Oaths and affirmations are covered in the third schedule. யாரோட oath of office cover ஆகல? Candidates for the election of Parliament cover ஆகாது. only ஒன்னுங்கிற ஆப்ஷன் கிடையல இல்ல. CAG இருக்கு. வைஸ் பிரசிடென்ட்டும் பிரசிடென்ட்டும் கவர் ஆக மாட்டாங்க. பிரசிடென்ட்டுக்குன்னு தனி ஆர்டிகிள் ஆர்டிகிள் 60, வைஸ் பிரசிடென்ட்டுக்குன்னு தனி ஆர்டிகிள் ஆர்டிகிள் 69. ஸோ இவங்க ரெண்டு பேரோட ஓத் ஆஃப் ஆஃபீஸ் இஸ் நாட் கவர்ட் இன் தி தேர்ட் ஸ்கெடியூல். ஓத் ஆஃப் சீக்ரஸின்னு ஒன்று இன்க்ளூட் ஆயிருக்கும். ஓத் ஆஃப் சீக்ரஸி இஸ் ஒன்லி ஃபார் யூனியன் அண்ட் ஸ்டேட் மினிஸ்டர்ஸ். தே ஹாவ் oath of office and oath of secrecy. சரி, ஓகே. ரொம்ப பண்ண விரும்பல நானு. ஸோ போங்க, வீட்டுக்கு போயிட்டு சொல்யூஷன்ஸ் அப்லோட் பண்ணுவாங்க. ஸோ கால்ட் யுவர் குரூப். எப்பவும் போல ரிசீவ்டுன்னு நினச்சி விடாம ஒரு தடவை கோ த்ரூ பண்ணிக்கோங்க. நெக்ஸ்ட் வீக் வந்து பாலிட்டி தொடங்க மாட்டோம். வில் ஸ்டார்ட் வித் ஹிஸ்ட்ரி. ஹிஸ்ட்ரி கிளாஸஸ் கம்ப்ளீட் ஆயிடுச்சா? ஹவு கான்ஃபிடென்ட் ஆர் யூ இன் ஹிஸ்ட்ரி? என்னோட ப்ரிப்பரேஷன் நான் ரெடி பண்ணிக்கணும்ல. Thank you all. Happy learning. See you. So tomorrow you won't be having any current affairs class. We will be meeting on Tuesday.